she'll give her slides. So she'll talk to the podium.
So good afternoon. It's an absolute pleasure to welcome all of you in such a good company. This event today is co-sponsored by a very interesting group of actors. We have the Ford School of Public Policy at Michigan University, the Consortium for Science Policy and Outcomes at Arizona State University, the Chemical Heritage Foundation, and finally, the Wilson Center Science and Tech Innovation Program. So within this program, I'm the director of the Biology Collectives project, whose mission is to understand and foster the democratization of converging technologies for and with citizens. So from portable genomic sequencers to artificial intelligence and affective computing to citizens who invent new solutions in health, this program aims to anticipate and enable the governance of open science and innovation. But it also keeps at its core the idea that none of our designs, none of our visions are free of politics. So our designs, our inventions reflect our values. Openness versus secrecy, monopolies versus inclusive innovation. And indeed, we have all gathered today to discuss a complex and important issue, a matter of concern that has driven our innovation models for decades and created subtle transatlantic differences in how we patent life. So we'll examine the legal, policy, and philosophical foundations on which the EU and US patent systems are built. We'll try to reflect on the kind of knowledge that is and should be patentable. We'll try to understand the political and technocratic negotiations, the fights and controversies behind who gets to patent the product of our biology. And to remind you of the importance, the crucial importance of this conversation, I can just mention or whisper 6 letters, CRISPR. And it's not a new brand of potato chips, it's actually the latest artifact in our patent politics. So it's a new genome editing tool that's actually driving the today's biotech industry. As very well said by Shobita in her book, what is patentable has become increasingly linked to issues of health, economic inequality, and morality, which means that in our digital bioeconomy, we may need to question the motives of those who seek genetic data commodification for corporate profit, but forget to share tangible benefits with the data providers, meaning all of us. Now let me introduce to you today's author, Shobita, and the 2 panelists, Dan and Richard. So Shobita Parthasarathi is an associate professor of public policy and women's studies, as well as the director of the Science, Technology, and Public Policy program at the University of Michigan. She's also a former scholar at the Wilson Center, and she's the author of Patent Politics, Life Forms, Markets, and the Public Interest in the United States and Europe. And the book is available outside on the 6th floor if you want to give a look and acquire it. Daniel Sarowitz is the co-director of the Consortium for Science, Policy and Outcomes, as well as professor of science and society within the School for the Future of Innovation in Society at Arizona State University. He's the author of several books, such as The Techno-Human Condition, but he also recently authored a manifesto titled Saving Science, which might resonate with or challenge Shobita's book. And finally, Richard Harris is an award-winning journalist with the National Public Radio, and is the author of Rigor Mortis, How Sloppy Science Creates Worthless Cures, Crushes Hope, and Wastes Billions, a very timely critique of how and why the research culture in modern biosciences often fails to meet our expectations. So now, Shobita, the floor is yours to help us unveil patent politics.
Wonderful. Thank you very much, Eleanor. Before I start talking about the book and the topics for today's conversation, I would like to give my thanks to two groups. The first is the Wilson Center. So as Eleanor said, I was a Wilson Center scholar quite a while ago now, embarrassingly long ago, I should say. And it was in those first few months that I began to do the research for this project. And over the year that I spent at the Wilson Center, they were really instrumental in helping me think about how to structure the project and to do the initial work. I also then spent some time at the Consortium for Science Policy and Outcomes DC office, and there too I was given the intellectual and resource support to move this project along, let's say. And so I'm very excited that both of those institutions, in addition to my home institution, are sponsoring this event. The second vote of thanks is to many of you in the audience who have supported me intellectually, emotionally, in a wide variety of ways, mentored me, and again, asked challenging questions, but also supported me when I didn't necessarily have the answers to those questions. I can't guarantee that I have figured out all of the answers to those questions, but my hope in the book is that at least I've asked them in empirically grounded ways and hopefully in nuanced ways and hopefully pushed the discussion, as Eleanor said, about politics and policy related to the patent system in particular, specifically when it comes to biotechnology, but I hope that it raises broader questions about the nature of the patent system and intellectual property more broadly. So now let me spend a little bit of time introducing the book. So when I started thinking about the book, I was very much driven, I think, by and interested in what a phenomenon that I think has risen since the 1960s. Of course, I think since the 1960s and throughout the 20th century and into the 21st, we certainly in Western societies have become increasingly dependent on science and technology. They order our lives and have benefited our lives in tremendous ways. But as we've become increasingly dependent on science and technology, there have been a number of questions and fissures about what responsibilities governments and governing institutions have when it comes to science and technology. To what extent are governments responsible for anticipating and thinking about questions of risk, of ethics, of environmental implications, of distributional and socioeconomic implications of science and technology? To what extent, what responsibilities do we have, as Eleanor mentioned, to the people who participate in the research that scientists conduct, that governments sponsor? All of these kinds of questions have arisen. To what extent, for example, should government science priorities be shaped by the concerns of citizens? So all of these questions have arisen. They've arisen in a variety of settings, from the courtroom to congressional hearings to the streets of Washington, D.C. and elsewhere. But one line of challenge and one line of controversy within that, but that often I think has gotten maybe is not as clear as these others, is around intellectual property, although in recent years I think it's clearer. And that is that there are a wide variety of questions that have arisen that are related to these broad concerns about the relationship between science and government, or science, technology, and government, that specifically have to do with the nature of intellectual property. Those are questions like who should own inventions, who is the rightful inventor, when there are questions about the subjects of research, for example, participating, what ownership stake do they have? What ownership stake does the government have if they fund the research? Are there questions about and concerns? Should we have concerns about enclosing the public domain? Should we be concerned if we're commodifying life forms? In particular, do patent systems implicitly sanction controversial areas of research? Are they enclosing areas of research that were done by, for example, indigenous communities? Where does the rights of indigenous communities figure in questions around patent systems and in increasing intellectual property regimes, because one of the things that's happened certainly since the 1980s, but over the course of the 20th century, is a rise in the number of patent applications and the number of patents granted. So in that space, it's not surprising that there's increasing concern about what the patent system is, where it figures in terms of shaping the implications of science and technology. And so, in particular, you see this, and you see these controversies in a variety of areas. You see them in biotechnology, which is the focus of my book. You see it in areas like software, pharmaceuticals, business methods. And these are the kinds of questions that arise. Do patents stifle early-stage innovation? Do they limit access to important and even life-saving technologies? Which seems like a strange question because the patent system itself seems like it's designed to, in fact, stimulate innovation. At least that's what we've been told for generations. As I said, are they enclosing the public domain? Are they implicitly sanctioning controversial areas of science and technology? And are exclusive rights awarded appropriately? Are the rewards really given to the right inventors? So it's that set of questions that interested me. And as I started to focus the book, I decided to focus on biotechnology because biotechnology, in fact, touches all of these questions arise in the controversies around biotechnology patents. And in addition, there have been particularly sustained controversies. So as I'll discuss today, the controversies over biotechnology began in the late 70s and early 80s and have continued essentially unabated since then. And so that tells us a very interesting story, and it provided me the opportunity to see how those controversies evolved and what that tells us about science, technology, governance, and in broader political and social context. The second thing that I did was that I focused this analysis in the United States and in Europe. This is where the controversies were happening, but I thought that it would be interesting comparatively for a few reasons. We tend to think about the US and Europe as being essentially similar, certainly when it comes to issues of science and technology capacity. We think about these places as similarly democratic, similar in terms of their economic orientation. And in fact, the US and Europe have also been at the forefront of pushing international harmonization of intellectual property treaties, patent and trade treaties in particular. So it stands to reason that the US and Europe would approach questions around the patentability of biotechnology essentially the same. Now, as Eleanor alluded to, in fact, that's not the case. There had been, when I started looking at these questions, a number of legal scholars who had pointed out that, in fact, in Europe, there's something called the Ordre Public Clause. And the Ordre Public Clause prohibits patents on inventions that are deemed contrary to public policy or morality. And that was generally the way that people talked about it. Sure, there's this Ordre Public Clause that affects patents every so often, but by and large, the United States and Europe are basically the same when it comes to intellectual property. But for me, that actually raised a number of questions. Why is there an Ordre Public Clause in Europe? And then as I started to dig, I realized that, in fact, there's a moral utility clause in moral utility doctrine, in the United States. It's just that it doesn't get used. So that, of course, led me to another question. Why does the moral utility doctrine not get used in the United States, but it does get used in Europe? Why does the Ordre Public Clause take on the meaning that it does to, as you'll see, essentially perform a bioethics function in European patent law? So as I started to unravel all of those questions, I began to see a much more interesting, I think, and nuanced story about the role of politics in the intellectual property systems, and particularly in the patent system. And more specifically, I would say what's interesting to me is that we tend to think about patent systems as all things, of all areas of governance, as highly, highly technical. And so to think about the ways in which politics figures in those seemingly technical spaces is what was the most interesting to me, and that I was, I think, able to unravel in some detail. So as I've already foreshadowed, I don't think about these kinds of questions like a lawyer, but I'm obviously looking at a legal domain. So I think it's worth my spending just a little bit of time talking about my methods. So I'm a social scientist. I do what's called qualitative interpretive research. So I do a lot of analysis and data collection of a variety of different sources of data, and then I bring that together and try to figure out social patterns and about social systems and social processes. And in this case, I would divide my research into sort of two categories. The first is looking at which is the main bulk of the book, which focuses on the controversies around what I call life form patents from the 1980s to the present. So the book talks about patents on human genes, stem cells, genetically modified organisms. And in doing that more contemporary analysis, I did a number of interviews, over 100 interviews with civil society actors, patent office officials, government officials, patent lawyers, scholars, journalists, etc. I also analyzed what are called patent prosecutions, which are all of the documents that are submitted to patent offices around a particular patent. And in the case of controversial patents, that also includes civil society submissions, for example. So I got to see those politics in action. I also did ethnographic observation at a number of congressional and patent office bureaucratic hearings, as well as at the US Supreme Court. And then I analyzed a variety of documents from patent offices and challengers, as well as law. But as I did this more contemporary work, I realized that I needed to have a historical component, and in part because, as you'll see, I'm making sort of an argument about the nature of these two systems and the political cultures of these two systems, and so I felt I needed to do a historical analysis. And so I then analyzed congressional hearings and court cases in the United States from the dawn of the modern patent system in the United States to the present, and looked at who was involved, how they talked about patent systems. And then in the European system, I looked at the history of the European Patent Office, as well as the history of the European Biotech Patent Directive, which I'll talk a little bit more about today. So that gives you, I hope, a sense of the kinds of data that I used in order to develop my conclusions and finally write the book. So I want to start at the end, which is to give you a sense of the main arguments in the book. And I would characterize them in a few ways. So the primary argument in the book is that political culture, ideology, and history shape patent systems and patents in really fundamental ways. And as I already said, it isn't the technical apolitical sphere that we tend to assume that it is. And in particular, what I argue in the book is that the US and Europe have very different approaches to thinking about the relative roles of government and the market when it comes to innovation. So I argue that in the US context, we have what I call a market-making ideology. And what I mean by that is that the role essentially of the government is to help create the market, but the market is the one that then does the moral work. So for example, it's the consumer, not the bioethicist, that's the ultimate moral arbiter in terms of what kinds of technologies are good, right? So the moral order gets produced by the market. By contrast, I argue that in the European system, they have what I call a market-shaping ideology. That is, they conceive of a moral order that exists outside of the marketplace, and the role of the government then is to ensure that the market it reflects that moral order and has appropriate safeguards to ensure that the technologies that are bought and sold in the marketplace are in keeping with a broader moral order. So the second thing that I argue in the book is that essentially these different approaches I suggest, and I'll talk about in just a minute, lead to different understandings, as I said, of patents and of patent systems. But as those places come up with different ways of thinking about patents, they, especially when it is sort of enrolled or rolls out in the biotech patent debates, is that they start to think very differently about governance, not just of the patent system, but I argue governance of science and technology generally. So that we see in these debates that they're thinking about the roles of patent systems differently, they're thinking about the meaning of the public interest in very different ways, they're thinking about what constitutes relevant knowledge and expertise differently, and finally, they're thinking differently about who is an appropriate participant in the patent system and what appropriate avenues of participation are. And then finally, and this kind of is sort of in some ways saying differently what I've already said, which is that our understandings and thinking about patent system problems and solutions aren't natural or self-evident, but actually conditioned by social and political context. And I'll talk about a little bit about that today, and in particular, I'll talk about the ways in which the US and Europe think about the ethical and socioeconomic dimensions of patents and the patent system. And the argument that I'm essentially making here is that in these systems, discussions about what is relevant to the patent system, what is appropriate, how these systems think, that is, the kinds of evidence and expertise that's brought to bear, are in fact conditioned by these broader political cultures, by ideology, and by history. So when we, for example, say that X is not relevant to the patent system, that's in fact a political move, right? Or when we say, look, you need to evaluate this case in this particular way, that too is also shaped very deeply by patent system politics. And my hope is that becoming transparent about the ways in which politics figures in patents and patent systems will help us, I think, get to a better place, a more better discussions, let's say, about the role of the patent system in governing emerging science and technology, because it actually allows us to open up a conversation where traditionally, especially in the US context, we tend to say no discussion should be had because the patent system is in fact irrelevant. So today I'm going to talk a little bit about the sort of historical dimensions. I'll set up the basic argument of the book, and then, as I said, I'll talk a little bit about the more contemporary debates around the ethics and socioeconomic dimensions of patents and of emerging science and technology. So as I said, I argue in the book that political culture, ideology, and history are instrumental in shaping and producing different approaches to patent systems and different understandings of patents in the United States and in Europe. And that is based on different legacies, I argue, throughout the book. So, for example, in the European context, of course, the Europeans had privileged systems, not patent systems, but they had privileged systems from the 15th and 16th centuries. And even in those early privileged systems, those weren't rights-based systems, but those were sort of monopoly systems where entrepreneurs were able to get a monopoly from the government. But even in those early systems, there were discussions, there were concerns about the socioeconomic dimensions of these monopolies. So, for example, the first patent law, the 1623 English Statute of Monopolies, has a clause that now is interpreted as being similar, a precursor of that ordre public clause that I mentioned. But in fact, that clause in that piece of legislation talks about prohibiting patents that might produce riots or other kinds of public disorder. And the reason that they talked about that is that they were concerned about patents that had been issued on daily necessities that were causing riots. And so they said, okay, there needs to be some government role in kind of mediating this. And that point, the point that government has a role in mediating the intellectual property system, is another thing that you see that starts early on in these early privileged systems before the modern patent system, but then is taken through into the more modern European patent systems that emerge in the 18th and more seriously in the 19th century, where there's explicit attention paid to the potential socioeconomic dimensions of patent-based monopolies. So there are, for example, categorical exclusions initially on food and pharmaceuticals. By the late 19th century, there are attempts to have compulsory licensing laws. There are compulsory licensing laws that are in a number of European countries. And what a lot of that shows us is not only that these governments are thinking about socioeconomic concerns, but that they see the role of the government as being a mediator between the public and the private interest, and that they see that the public and the private interest are distinct things that the government has a role in mediating. So to fast forward a little bit, the discussions around the development of a pan-European patent system emerge in the post-war era, and by the 1970s, when the European patent system emerges, it echoes this approach. It kind of does away with some of these exclusions, but it also maintains a lot of them, and I argue sort of again reinforces the idea that the government is playing this mediating role, that there is a difference between the public and the private interest. In the US context, there in some ways are a lot of similarities. So just in both of these contexts, you have a system that is focused on driving innovation and increasing technology. But I argue that in the European system, they're much more inclined to think about it in moral and socioeconomic terms, whereas in the US context, they're thinking and talking in technical and legal terms and eschewing the idea that morality or socioeconomic issues are relevant in any way to the patent system. And you see this in the early days. There are attempts to put limits on patentability in various ways, and especially when, for example, their European counterparts are bringing in compulsory licensing legislation, American congressmen are saying, why would you have compulsory licensing legislation? You should trust the inventor. The inventors are good moral actors. And that point will come back, you'll see in the biotechnology debates as well. And another thing that's very interesting about the history of this system is that as I think many of you may know, it's intellectual property is very famously a part of the U.S. Constitution, right? And in fact, it's seen as a driver for the American economy and American social good. That is that, if we have a healthy patent system, we'll have lots of technology, we'll be able to grow the economy, social benefit will result. And as part of that, there was, in fact, a lot of encouragement to have everyone participate in the patent system. So application fees were relatively low. There were public displays of patented inventions. In fact, what today is the National Portrait Gallery is the old patent office building. And in fact, there you would have these public displays of patented invention. And the idea was to get everyone excited. Right? So, and other scholars have talked about it in terms of the democratization of invention. But the flip side of that is, of course, the assumption that everyone is a prospective inventor, right? And so to go back to these issues around the public and the private interest, the assumption is also that the inventor's interest is the public interest. So it's not surprising then that as the debates evolve, it's very difficult to disentangle those two things, especially in the more recent debates that I'll talk about around biotechnology. The other thing that I want to make a point of is that there's a strong emphasis on ensuring what scholars in science and technology studies and science and technology policy talk about as procedural objectivity. That the way to emphasize and ensure the public interest is to provide the appearance of transparency through a strong reliance on science and scientific evidence, as well as the law. And you've seen that other scholars have written about this in the context, for example, of risk regulation, but you see that here, public interest being interpreted in that way here as well. So I'm going to fast forward now a little bit to the biotechnology debates. So as some of you may know, in the late 1970s, or sort of mid to late 1970s, there was a lot of excitement about biotechnology. University scientists were starting up companies. There was enormous promise. The horizons were endless. And at the same time, there were these questions about whether or not the products of biotechnology were patentable. And there was a strong argument in favor of patentability because the idea was that if you, in fact, were allowed to patent these objects, that would help to stimulate the biotechnology industry. And so there has been, as I suggested, a lot of discussion about these questions about whether or not life forms are patentable. Should they be patentable? Those were ethical questions that arose. Are these life? If it's life, then it shouldn't be patentable. But the questions that I focus on in the book are questions of governance, right? So the questions that I'm interested in are who should make these decisions about patentability, on what basis, what kinds of evidence and expertise are relevant in having these conversations, and then more broadly, what's the role of the patent system in governing this emerging area of science and technology. And I argue that at the same time that these debates are occurring about patentability, they're also implicitly making decisions about the nature of the patent system as a space for governing emerging science and technology. So in the US context, the debate starts with the famous Diamond versus Chakravarthy case, where Ananda Chakravarthy, a scientist at General Electric, develops a genetically engineered microorganism that can eat oil. And so General Electric, his employer, goes and tries to get a patent. Initially, the patent office says no. After a bit of wrangling, the case ends up at the Supreme Court. And like any garden variety patent case, you had amicus briefs, friend of the court briefs, that are filed from universities, from biotechnology companies, from scientists, from patent law associations. But for the first time that I can find in my research, you had an intervention from a civil society coalition led by Jeremy Rifkin, by now fairly well known as a biotechnology watchdog. And in his amicus brief, he raises a bunch of questions that are completely unfamiliar to the patent system. Questions about whether or not patenting this life form is ethical, what are the ecological implications, what could the socioeconomic implications of these kinds of monopolies be. He invokes the expertise of philosophers. He also invokes National Academy of Sciences reports, but in ways that are kind of not seen in the patent system, about the environmental implications of monopolies and on crops, for example, and the loss of biodiversity. Unfortunately, he ultimately, in that position, loses, and the Supreme Court rules in a split decision that anything under the sun made by man is patentable, and in so doing, they essentially dismiss Rifkin's arguments by saying, listen, the patent system is a really narrow domain. It doesn't deal with all of these things. This is only about stifling or stimulating innovation. A few years later, the European Union is also thinking about developing its biotechnology industry, and the European biotech industry goes to the Commission and says, we want some harmonization of the laws across the European Union, and they say, help us. So the European Commission issues a law that says that biotech patents are going to be allowed, and they take it to the European Parliament. Well, the similarities, let's say, end there. At this point, the European Parliament sends this piece of legislation to a group of stakeholders, including labor unions, farmers, and breeders, and they say, no, this isn't a technical question. This isn't just an economic question. These are ethical questions and socioeconomic questions, and those are the kinds of things that we need to deal with, and these are explicitly political and policy questions, and we're the ones who need to address them. This EU directive for the legal protection of biotechnological inventions then takes 10 years to pass. It goes through multiple iterations. At what point it entirely fails, it's voted down. It comes back in an amended form. And eventually, the directive that's passed in 1998 has a variety of exclusions. Those exclusions include prohibitions on patents that involve the commercialization or exploitation of a human embryo. They require the European Patent Office and other national patent offices to do a weighing up test when they're considering the patentability of genetically engineered animals, considering the suffering of the animal against the benefit to humankind. There are farmers' privileges and experimental use exemptions that are reiterated in those in that piece of legislation. And I say all of this to make a couple of points, right? So the first thing is to make the point that, in fact, the questions that are asked in the US and European contexts are different, right? So in the US, it very quickly becomes a narrow question about whether or not this microorganism is a product of nature. So the question of, is this a life form, is entirely irrelevant. And with that go the questions around ethics and commodification. And then the court further says, as well as the other amicus briefs, these other kinds of messy issues you're raising don't belong here, even though the civil society coalition at one point says, this is something that should be decided by Congress, not by the courts. Obviously, at the same time, trying to expand the discussion, right? Whereas in the European context, it's not only a different place that the discussion is being had, but an entirely different set of questions and a different kind of evidentiary basis that comes to be seen as relevant to these discussions. And those initial settlements matter, but one of the things I argue is that then just gets amplified in the years since. And again, you could argue that the differences in patentability are relatively small, but what's more important to me is that the differences in governance are in fact quite quite significant. And that, I think, has broader reverberations for the governance of technology much more generally. So I'm going to, as I said, talk a little bit about managing ethical concerns as well as socioeconomic concerns before I wrap it up. So as I said in the book, I cover the, 1980 to the present in terms of the controversies. And so the places where the questions about ethics and the relevance of ethics to the patent system comes up most significantly is in discussions around genetically modified animals and in the patentability of human embryonic stem cells. So just as I said, right, so in the initial Diamond versus Chakravarthy decision, it seems like the US patent system is not particularly interested in engaging with these kinds of questions, and that gets amplified in the debates around genetically engineered animals. And so one way to talk about it, I've kind of joked, is that it's sort of, there's a Goldilocks approach to the civil society engagement, and there, I should say that there are settlements in both of these places, but that doesn't stop civil society engagement. In both the US and Europe, there's a lot of activism that takes place. And so the civil society groups in the US, which include farmers and environmentalists and animal rights activists, as well as those religious figures, those concerned with biotechnology, they go to Congress and they're rhetorically rebuffed. They try the courts, and they're legally rebuffed because the courts say you don't have legal standing to participate in this conversation. They try the patent office directly, and the patent office officials say you don't belong in this expert space. This is not where these kinds of discussions take place. And so in the book, I talk about how essentially what happens, and I think that this happens in different ways across science policy institutions, is that a very strong expertise barrier emerges that plays a significant role in keeping not only these unruly participants, but also these alternative forms of potentially relevant knowledge and expertise out of the patent system. By the 2000s, when the stem cell debate is in full swing, what you see is that these groups have sort of stopped trying to make the ethical kinds of points. In fact, some of the same kinds of groups are still involved in challenging these patents, but they shift their concerns entirely. And so they start to talk about utilitarian worries about whether or not patents on stem cells are going to stifle research, whether it's going to hurt healthcare. And I point this out. I'll take you back to the world of, let's say, 2002, right? So in 2002, vis-a-vis stem cell research, you might recall that there's a vigorous debate about the morality of conducting stem cell research. President George Bush has passed this restrictive executive order that limits federal funding for stem cell research. At the same time, there is a patent on stem cells and as an exclusive license. And so there's a lot of concern by scientists that this is going to restrict research and eventually restrict availability of therapies. And what I demonstrated in the book is that it's interesting, right, that the moral debate that's raging in the context of research almost doesn't touch the debate around patentability, number one. And number two, the debate that emerges around the impacts of research on healthcare also kind of dies out because there's this appeal to the morality of the inventor. The inventor is a moral actor. They also have an interest in ensuring wide availability. So, and there are a number of attempts to try to ensure that there will be widespread access, and those generally fail in this context. By contrast, in the European context, there's a vigorous debate focused on the commodification of life, and in particular focused on whether or not these patents on human embryonic stem cells are in fact hurting human dignity. So the clause in the Biotech Patent Directive that further specifies this ordre public clause that talks about prohibiting patents that involve the commercialization or exploitation of a human embryo is invoked, and ultimately stem cells are not seen as patentable in the European Union. Just a bit earlier, and this sort of debate goes on for a long time, genetically modified animals also are debated. There's a strong civil society involvement in this conversation, and the European Patent Office considers these questions and has to figure out how to implement this weighing up test that I mentioned earlier that the biotech directive lays out. And so they're struggling to figure out how to incorporate ethics, but they kind of figure out, that they're going to do it, but they're not going to take empirical evidence, that they're going to do an abstract utilitarian analysis. So there are a couple of things that are interesting about this in comparative perspective. The first is that in the European approach, ethical concerns are seen as relevant, and the question is what constitutes evidence of an ethically problematic invention or ethically problematic patents. And the second, and in the US context, there's sort of a exclusion, and so there's no discussion about what constitutes relevant evidence of ethical implications. The second point is that in the US context, there's also an exclusion of these, sort of, as I said, unruly participants, right? These people who are newcomers to the patent system by saying, you don't understand the system, you don't understand what's going on. These are issues to be dealt with elsewhere. Whereas in the European context, they're sort of trying to figure out how to incorporate these voices. They allow these oppositions in, they allow these people to participate in these hearings, but that raises a different set of questions about what role does the public play in the patent system. And I wanted to talk a little bit about socioeconomic concerns, in part because in the US context, perhaps in the last 10 years, the most famous example of thinking about patent issues is the Myriad genetics case, the Supreme Court case that was decided in 2013. So as many of you may know, there was this biotechnology company by the name of Myriad Genetics that owned patents on genes linked to breast and ovarian cancer, and they got those patents in 1996 and 1997, and for many years there was a lot of quiet grumbling in the scientific, medical, and patient communities, but there wasn't a lot of outward activism. But in 2007 and 2008, the American Civil Liberties Union gathered together about 20 plaintiffs from those various communities and launched a lawsuit. And I think it's really important and instructive that it's an outsider to this system, the American Civil Liberties Union, that plays this catalyzing role. And so what's interesting to me about this lawsuit, there are many, many things, but one of the interesting things to me about this lawsuit vis-a-vis socioeconomic concerns is that the ACLU, it's the ACLU, right? So they come into this, they're interested in this really because they are concerned about whether or not these genes are stifling research and healthcare. But in order to play within the system, they had to rest their arguments on product of nature questions. That, if you remember, is the question that was in the Chakravarthy case, right? So they were focused on a legal question, on a narrow legal question, not on these broader concerns that really drove them to the table. The second thing is that, as I said, they marshaled 20 plaintiffs who represented a wide variety of the kinds of people that were affected by this decision. But in the end, only one plaintiff stood. And that was enough for the case to go to the Supreme Court. But it's notable that that one plaintiff, the reason that plaintiff stood was because essentially they were an economic competitor. And that was the kind of plaintiff that the patent system, the US patent system, could recognize as being relevant to discussions about patents. In this context, it didn't make sense, given the logic of the patent system, that, for example, patients or scientists or healthcare professionals would be relevant to these kinds of conversations. In Europe, a similarly diverse array of groups challenged patents at the European Patent Office using this opposition mechanism, which is the mechanism that a lot of these groups use throughout these cases. And those patents are ultimately revoked, but the Patent Office but it does so on technical grounds. And it says, this ordre public clause is really narrow. It only deals with commodification, ethical questions. It doesn't deal with the socioeconomic concerns, which are really what's driving your worries about these gene patents. So genes are still patentable in Europe. But what's interesting to me is that if you just look at that decision, then you might say, well, that's not, that's a technical argument. But what's interesting is what happens around this decision. So at the same time, the European Patent Office is issuing reports that essentially say, we recognize that patents can have socioeconomic implications. We have to deal with this in some way. Maybe we should narrow the scope of patents in order to make it easier for people to invent around these patents. The European Parliament is strongly condemning the European Patent Office for issuing these patents in the first place and saying that the Patent Office is the central place that has to help safeguard the public health, and it needs to be publicly accountable. And this is very interesting, right? Because it sort of betrays the idea that the definition of what constitutes public accountability looks quite different from the view of the European Parliament than from the view of the US Congress. And at the same time, national governments are passing compulsory licensing laws that are focused on gene patents. So at the same time that this is happening, in the US, there's not only this court case that I mentioned, but there's also a discussion about there's a requirement for the Patent Office to consider whether or not gene patents affect research in healthcare. And in these hearings, the Patent Office officials begin the hearings by saying, we are forced by Congress to hold these hearings, but they're based on a false dichotomy, right? They don't understand that patents don't have these kinds of negative implications, and that's the fault of the healthcare system. It has nothing to do with patents. And you see this in other places as well. Just in the fall of 2015, the State Department, in reaction to a UN report on access to essential medicines, the State Department comes out strongly and says, the UN doesn't understand that the patent system creates innovation. It can't possibly stifle access to that innovation. So in fact, what happens in the US context is that the US patent system denies the idea of a patent-based monopoly in the first place, and therefore denies the idea that there is relevant evidence and expertise about socioeconomic implications. Whereas again, just as in the case of ethics, in the European context, there's a recognition that patents might create problematic monopolies, and the struggle is over what constitutes relevant evidence and expertise to demonstrate that these potentially negative implications. So I'll just stop with a couple of observations that hopefully I'm just reiterating. So as I said, the main argument in the book is that the way we think about patent systems and the way we think about the role of patent systems in governing emerging science and technology is not natural or self-evident. It's deeply shaped, fundamentally shaped by politics. And what I argue, as I've said, is that it's shaped by political culture, ideology, and history. So then if we kind of take that question out, right, is the patent system relevant, I think then we have to start having a set of conversations, which I hope will continue today, which is, what role then could patent systems play in governing emerging science and technology? And there are a few places, I think, that are interesting to think about. The first is that, of course, patent systems see scientific fields early on, the early stages of new industries. They might be able to help us anticipate where and how socioeconomic concerns or distribution concerns might arise. But this, of course, would require us to think quite differently about what constitutes appropriate or relevant patent data and expertise. They might help us flag public concerns relatively early. And I think, of course, and this is the broader point, which is it should, I hope, force us to have a more sophisticated conversation about what constitutes the public interest vis-a-vis the private interest and vis-a-vis the inventor's interest. But I am a comparative scholar, and so I think it's important at least to state that we have to think, when we think about proposals, when we think about the role of the patent system in governing science and technology, we have to realize that we can't just take one idea from Europe and drop it here or vice versa. All of these ideas, whether it's a standing ethics committee or a chief ethics advisor or thinking about broader legal standing requirements or opportunities for public engagement, have to be analyzed and thought about with the seriousness of the political and social context in mind. So I'll stop there, and I look forward to the conversation.
want to sit in the middle?
Yeah, why don't you sit?
Sure.
We'll talk.
We can, yeah, we can.
One of you guys has to start, obviously. So I've been talking.
Okay. Well, first of all, thanks for making me read your book. The ugly truth of being an academic is you actually don't have time to read anything unless you're a graduate student. And so I actually look for opportunities that force me to read things. So when it was, I'm actually a lousy scholar. Shobita is a wonderful scholar, and one of the things that tells you that somebody's a good scholar is they find a really interesting lens to look at something complicated, and then they dig in. And I think you recognized a long time ago that patents and patenting systems were really interesting ways to look at something very complicated, the intersection of many different social and political factors. So I think it was just a kind of a brilliant insight on your part, and the book is a wonderful manifestation of that. So from there, there's lots of issues I wanted to kind of talk about, and one of them is so patents and the patenting system is one. It's one institutional and legal venue within complicated innovation systems, and so one thing I wanted to kind of think about, and maybe the three of us can talk about this, is does it really matter in terms of outcomes whether the patent systems are different? And what I'm thinking about is so the U.S., we have a culture that's much more focused on the rights of individuals. You talked about the kind of greater primacy given to the markets, but there's a flip side to that too, which is that it seems like there's more places to intervene politically. And so I was struck by, in thinking about, say, the embryonic stem cell debate, the difference in the politics of that in the U.S. than in Europe. So in the U.S., the interventions on behalf of, one could say, the dignity of life were actually coming from the right. They were manifested especially in the Bush administration, with the significant obstacles put on behalf of embryonic stem cell research, and it just struck me that maybe what's going on is just different ways of democracies expressing themselves. So and it also struck me about how the ethics of these issues seem to have very different kind of political alignments in the U.S. Versus Europe. In Europe, it's mostly what we'd consider, at least by U.S. standards, kind of more left-leaning, socially progressive organizations that are behind the effort to reduce or eliminate the commodification of life. In the U.S., it seems more like that comes from the right, and in fact, bioethicists mostly were aligned against the stem cell moratorium on stem cell research and destruction in the U.S., whereas you see the opposite case in Europe. So one thing that I just began to wonder about is how much of the governance problem or the governance issue around these technologies is really about patents per se in the patent system, and how much of it is about kind of different traditions for intervening in the innovation system, different venues for intervening, and also really different politics about intervening. Because let me just say one final thing here is there's an interesting assumption on, and tell me if this is right, because you only write about the patent system, so maybe it doesn't apply more broadly. But you can still have commodification without patents. So you can spend all your time trying to intervene in the patent system, reduce the patentability of life forms, and they can still be commodified through the private sector, through the practice of medicine or in vitro fertilization, all this other kinds of stuff. So I almost wonder if the obsession with the patent system in Europe kind of created a limited intervention, and in fact, could in the end not have any effect on whether these life forms are commodified. So none of these are questions, but they're all kinds of things that the richness of your discussion made me think about.
So that's really interesting. So I guess I would say, well, you said something that I want to clarify, and you said it at the outset and you didn't return to it, but you said, does it matter in terms of outcomes? And I'm wondering what you mean in terms of what you were getting at when you used that.
Yeah,
term.
well, I meant that democratic players have certain intentions. They're trying to achieve certain outcomes, and do we see those general? I mean, and many of these have to do with some sense of what society ought to look like, what we ought to allow and what we ought not to allow. So do the ethical agendas and the moral agendas that are being exercised on behalf of or via the patent system in Europe, are they ultimately doing a better job achieving their goals? For example, the decommodification of life forms than similar efforts in the United States. So maybe that's too concrete a way to look at it, but given that these political actors are intervening for a purpose to try to achieve something, I guess what I was after is it working? Are the political aims being achieved better in Europe than they are in the U.S.?
So I'll answer another question that what you said made me think about first, and then I'll try to address that. So I think, for me, the patent system, I completely agree with you. And as I wrote, I realized that as I did research, I realized exactly, I think, what you said, which is that I was studying the patent system, but in fact, the phenomena that I was talking about is much more broadly about the way that politics is arranged around these two innovation systems. And I hope that you can take my book as an intervention into that, to say these are the kinds of alignments that exist and the kinds of blind spots that exist in terms of these politics, right? So I think from that perspective, and one of the things I say in the book is, we have in both the US and in Europe concerns about, there are these concerns emerging, both about access, availability of technology, as well as the morality of science and technology. And one of the things that's interesting to me is that the debates around the patent system can, in fact, be reflected elsewhere, in the sense that elsewhere in the innovation system, there are certain kinds of conversations that you can't have, that we're not having. And they're happening, those conversations are happening in the European context. They're happening in the patent system, but I would argue they're happening elsewhere, not just in the patent system. And so one of my hopes with the book is to reveal through a comparative analysis those blind spots, those kinds of questions that are emerging in one place and not emerging in the other place, and force us to ask those questions in different places. So I see, so it's not just about the patent system. It is, in fact, about sort of, this is one narrow window into a broader innovation system. In terms of whether, and I say that, I'll just say, just to go back to the empirical material, because I'm often quite comfortable there, is that, for example, the kind of idea that we don't question the inventor, that the inventor is the quintessential moral actor and they're doing good, and so we shouldn't challenge this patent system, we shouldn't challenge the innovation system and whether or not it's achieving social benefit because we are its beneficiaries, is I think part of the ideology that creates the kind of arrangements in the political environment in the U.S. context but on the other hand, I think in the European context, there's much more freedom to ask those questions in the patent system, but also outside of the patent system as well. And so I just happen to focus specifically on the patent system. In terms of whether or not it matters in terms of the outcomes, are these folks successful? I guess you'd have to ask essentially whether or not these kinds of concerns are being addressed better elsewhere, right, outside of the patent system, right? And I think my argument would be that no, right, in the U.S. context, right? And I think better in the European context, but I would never say, it's great in the European context and not so good in the U.S. context. But if you're looking at the nexus of thinking about the implications of science and technology, thinking about, the role of the public in shaping science and technology, or thinking about, are we ensuring that our innovation systems are really achieving social benefit? I don't think we've made a lot of progress in the U.S. system, unfortunately, and the patent system is the hardest case. That I would concede. But the kinds of blind spots I think exist in a lot of places in the U.S. system. Whereas I think in the European system, as I said, they're having the conversation. They're a mess. I'm not saying that they've figured it out, but it's very difficult to have that conversation.
And let me chime in here with a couple of observations and questions. One of which is, as you set up in your book, the European Patent Office sort of was formed really independent of the European Union or whatever. It's its own special entity, and it was sort of a way of integrating this together. And so that, I think, in some ways, that gives it more power than the European Union on these specific issues, because those issues get debated in a sort of a place where there's consensus. In the U.S., of course, the Patent Office is part of the U.S. government, and so then if you broaden the question to say these are questions that the government should be discussing, then I kept thinking, well, why shouldn't this be Congress? Aren't they the people who are supposed to be weighing not only the economic issues, but all the broader and social issues? And I kept sort of thinking, is this really, certainly the way our patent system is set up, which is very technocratic, would you really want those people to try to answer these non-technical questions? And you illustrate brilliantly how poorly they do when they're thrown these questions. They just try to deflect them. They're completely not equipped to do this. And so that was one thing I was thinking about as I was reading your book. The other question I had was how much these two systems interplay with each other. Because if you, and I'll start with a sort of a thought about how the biotech industry really got going here through the Cohen and Boyer patents, right, back in the 1970s, and we were off to the races with that, and that really ended up stimulating a lot of economic interest. But that also means that if Europe turns and says, "Can we say no to this?" and basically see all of these economic benefits, I think there's a lot of interplay that even if we might come at it with very different attitudes, I would suspect that these economic interests very strongly end up creating an incentive for us to come to the same conclusion, no matter how the systems are set up. So I wonder if you want to take on those.
Sure, those are also fabulous questions. So in terms of the role of Congress, right, so, today of all days, or this week of all weeks, I guess, or this year of all years, it's easy to dump on Congress. I do it often, and with gusto. But what I often say when I'm asked a question like that is that there are lots of ways we can think about the role of the public or the role of those kinds of concerns in shaping technology and its implications. And there are lots of experimental ways, some of which is conducted at CISPO and Arizona State, but elsewhere in the US and around the world, that think about how we can gauge, anticipate, think about the implications of science and technology and build that in a democratically representative way. So sure, technically it is, the way, given the structure of our system, Congress seems like the place that these conversations should occur. But there's also other potential spaces, right? Especially given the realities of Congress, I think we can potentially think of them. I mean,
But are you trying to do an end around here? Are you? Are you just thinking about the practical realities of how Washington is today, and it doesn't meet your expectations? But I mean, sort of stepping back, sort of institutionally, shouldn't this be in Congress as opposed to in the more technocratic office?
So again, I'll turn to the empirical, right? So one of the things I talk about in the book is how the FDA. It's a brief passage in the book, but as I was looking at actually the public comments around gene patents, I was fascinated because it wasn't just technocratic the way the U.S. Patent Office thought about public comment. It was that it was completely bizarre, right? So they had these categories of companies, individuals. I forgot the third category, and they sort of classified the American Civil Liberties comments as companies, and it sort of doesn't make a lot of sense, right? And so that made me curious about how public comments are categorized, right? A pretty simple question. So I went and I looked at the public comment mechanisms in the Federal Register, and I happened to look at a FDA Federal Register notice around e-cigarettes, and there were something like 50 categories of publics. Right, international non-governmental organization, national governmental organization. So I thought to myself, okay, this technocratic agency, right, has a much more sophisticated understanding of how to conceptualize the public, right? Even that is a move in a direction that takes that thinks in a more sophisticated way about the public, and you can see that certainly in the in the EPA as well. I mean, there's also, the Patent Office already has mechanisms that are designed to hear from and consider the public, whether it's public comment, whether it's town halls. It's a matter of how it has a public patent advisory committee. It's a matter of how it conceptualizes that public that I think could change. On the Congress side, right? I mean, I always kind of tut when my friends refer to the Office of Technology Assessment, the defunct Office of Technology Assessment. But institutions like that have existed in Congress. Those are the kinds of places where conversations like this could happen, but those were also very think tanky. They weren't necessarily tied to decision making, right? One of the advantages of having those kinds of conversations inside of the bureaucratic agency is that they can be more closely tied to decision making. When it comes to the European counterpart, I think you're right to say that the EPO is structurally different, right? Because it exists outside of the European Union, but it is also deeply tied to the European Union. So it has not to my knowledge ever disagreed with one of the directives that the European Union has, the European Parliament has passed, the European Parliament and Council. So it is very much affected by what's happening in the European Union. And I'm not just talking about, well, the focus in the book is very much on stuff that's happening at the European Patent Office. The national patent offices are also in this story as well, and they're similar in their structure to the U.S. government. So
And so that gets to my second question, which is, so what happens if there's a patent issued in the U.S. that's an economically viable patent, and Europe may have some moral qualms about it, but they also must have some economic qualms about saying we're not going to allow this patent? How does that play out?
So this is a really interesting question, and it's also, when you think about the Cohen and Boyer patent, one of the things that's really important and interesting about it is how cheaply they licensed it, right? Which then enables.
They didn't know better, I guess.
They didn't know better, exactly. That's what the research shows, is that they were very green, and they didn't in fact know better. But I think that yes, by and large, there is a lot of there's certainly a lot of communication. They work together to make sure that they're harmonizing their approaches to patents and making similar decisions. The industries are also often tied. But I think that actually betrays the fact that, innovation systems are really complex, right? So you can patent one thing and then you can patent around, patents have all kinds of reverberations, or you can not patent it and other kinds of technologies result. I mean, that's why when people talk about the impacts of the gene patent decision, they say, well, it's good for some innovators and it wasn't good for other innovators. Because in fact, there are all kinds of different innovators operating that could benefit or not from these decisions, which I think actually opens up room for having conversations about the implications. Because in fact, I'm not sure that the questions of patentability in the long run matter that much. So then the question is, these are symbols of what the role of the state is and what the role of the state in governing technology are. Those might be even more significant than what the patent language is in any particular
They're also, aren't they also symbols of just kind of differences in political culture? And I mean, what your question just made me think of it's not a patent issue per se, but the whole GMO thing, right? And we know that to a pretty significant extent, Europe has been successful in at least slowing the tide of the spread of GMOs to Europe. And we know from good social science the reasons that they do it, and it's not because they don't want Monsanto telling them what food to eat, and they don't like American corporations, and they're afraid their tomatoes will start tasting like our tomatoes, and they like the way their landscapes look. They don't want them to look like Iowa and things like that. But they talk about it in the language of science because that's the language that the trade agreements force you to talk about things in. So I mean, that seems to me to be exactly the same sort of issue, and I think it does suggest that you can have, I mean, the governments, I think, did try to really fight on behalf of GMOs in Europe for a long time, and they kind of gave up to a certain extent because it was clear that citizens weren't that interested in it. So I think there is some potential for differentiation despite economic interests, but it should also be said that affording food wasn't really a big issue in Europe. If it had been, maybe if there had been scarcity issues, maybe it would have unfolded in a different way. So you could say maybe Europe had the luxury to reject GMOs. But the point is, I think maybe these are just bigger kind of cultural and political issues, and that the patent debates are just kind of one way of looking at them in a distilled kind of through a distilled lens. So.
Yeah, I think that's right. And I also would say that I mean, as I was saying, right, the one of the questions that I often get is, well, what are the implications? Doesn't this mean that, Europe is much worse off in terms of innovation than the Americans, right? And that's first of all, I say, well, no, because as I said, innovation is complex and these are complicated ecosystems and patents play a role in it. And in fact, you can have different approaches in terms of culture, political culture and ideology, and they're still rolling along fairly well, right? Both of them.
Yeah, I mean, in terms of quality of life indicators, there's really probably most of them do better than we do.
Right. The other question, this is not directly addressed in your book, but the other thing that left me wondering is the thing that concerns me most, or that I've been thinking out more about with patents, is how much economic impact it's having on drug development, and the fact that that patents they find clever ways to extend them and so on, and it's one thing that keeps the price of drugs extremely high. It's a heavily used mechanism for that. And you're right, we do not. If we could march into the patent office and demand some changes, that would be one thing, and we clearly do not have that direct avenue. But
well, actually, it's funny you use those words, because legally we do have that direct avenue. We just never exercise it, right?
Right, actually, right.
Well,
the
right,
march-in,
right, the march-in rights. Yeah.
But we don't. Yeah, but so how could we address those issues?
Well, I mean, I think the first step is to think about them and recognize that those are issues. I mean, I find myself often in conversations where people don't realize that that march-in rights exist, where they think that if it's taxpayer funded, then there's no intellectual property. If a university is doing it, that there's no intellectual property issues. That these kinds of things, either they believe that, or they say, oh well, patents are really beneficial, and so it's this sort of the early days of the Myriad patents. Oh well, we have to accept this because benefits will accrue. So one answer is sort of awareness that in fact these are mediating these relationships. These are incredibly important. I mean, there's a conversation right now about U.S. Army has developed a Zika vaccine, right? And they're going to exclusively license it to Sanofi, and they're not requiring that Sanofi, and that's not even a march-in issue. That's like the U.S. Army developed it, right? So the Sanofi, they're not asking that Sanofi. They're not saying there should be non-exclusive licenses. They're not saying you should keep the prices low. So
Right.
there's
That's the point. They're not.
So there's a we can see what the picture is going forward, right? So there's.
I guess the argument there is that if nobody had an exclusive sort of right to it, they wouldn't find enough economic interest in developing something that's obviously at this point has a pretty small market but.
So that's where you get to the two different kinds of interventions, right? One is the interventions on the economic or technical or market player side. This is where conversations about prizes comes in, or other kinds of alternative intellectual property incentive systems that might address these kinds of things. I was just at Oxford University, where the people in the pharmacology department there are thinking in really creative ways about open innovation. They haven't figured out how to deal with it once they get something and they have to do the licensing with the drug company. But, at the early stages, it looks interesting. But what I hope that my book does, in addition to, kind of shining a light on these questions, is to open up a conversation about governance and public engagement, right? So I think that there's questions about pressure on NIH and Congress potentially about march-in rights. I mean, people don't know, so nobody's asking these questions. But it's also about forcing these places to have conversations about how are you thinking about this? How do you think about march-in rights? We've never exercised it, right? But what about public?
I think it came up in the AIDS crisis.
It came up in Cipro. It came up with Cipro.
For anthrax.
Yeah.
Oh, right.
Yeah, that's when it was threatened, but never actually used.
Right. A colleague of mine did a story fairly recently about a different approach, which was thinking about the hepatitis drugs and hepatitis C drug. And there was sort of a thought experiment. What if the U.S. government bought Gilead for $90 billion, and it would actually be cheaper than having to buy all of their drug products and reselling their drug products, because there's a $300 billion market for it. And so, I mean, that's another way of...
You may have your finger on this pulse, but there was a common wisdom in town just a couple of months ago that something was going to be done about drug prices. Do you still see that? Are people still saying that?
I don't think it's materializing in any meaningful way.
The one other thing I just wanted to add on this point is that in the U.S. context in particular, given the centrality of the courts in the discussions, I think that the issues around legal standing are really important. So if you look, for example, at the environmental policy arena, right, the environmental policy, because of the National Environmental Policy Act, NEPA has broader standing requirements because, who can speak for the environment, right? Trees can't talk. So, you had to come up with people, right? So, one of the things that I think is problematic in the U.S. patent system is that all of the players are sort of in some way interested in expanded patentability, right? And not asking certain kinds of questions. But those are the only those are the only players who can really figure in the court cases, which is where most of the action happens, right? So that's another way to think about it is, can we think about expanded legal standing requirements? Can we think about, you have these organizations the ACLU is interested, but obviously this is not their central area. You have Knowledge Ecology International, the Public Patent Foundation. You have these NGOs, but they're tiny organizations that can't manage all of this.
Well, there's some foundations, though, that are beginning to put big money into this, like Open Society.
Open Society has funded the Public Patent Foundation, and yeah, I mean they're putting money into this, but you also have to have mechanisms, right? And the problem is that that all of the places where you could have other interests are kind of blocked off from those other interests by design. And I think that's a difficult thing. The other thing I'll just mention is that, and speaking of other small NGOs, there's the Universities Allied for Essential Medicines, which is this student group that's now spread, that's about pressuring university technology transfer offices to think differently about these questions, right? Universities that are ostensibly operating in the public interest, but that define the public interest by, getting patents which they'd see as the way to get technologies out there, right, into the
and how to to fund themselves too.
Right. Yeah, well, that's actually what's happening,
yeah,
right? So the idea of the student groups is to force technology transfer offices inside universities to think about public interest in a different way.
Right, and to raise their tuition then, and when they
that's the problem, right? They're not thinking about that part of the equation, but yeah, obviously it ties to lowered funding that universities are getting.
I was hoping we can get some questions from the audience, and that might link with your conversation. I had one first that I just want to throw in as we collect other questions. Your first slide had that picture with stop patenting life and stop patenting our own genes. So essentially, stop patenting what's nature or what our genetic secrets are. But in the meantime, we increasingly impose a form of mechanization on biology. So we consider our cells like factories. We print DNA in the lab like on assembly line. We cut and paste genomes. So if we go more and more into this optimization of our biology, can we still see patents as political and socioeconomic tools to not commodify nature? If we can almost not see some of the changes we made with CRISPR on genomes because it becomes more and more natural, how do we still deal with those tools as in our democratic debate? I leave you with that, and then I'm going to look for hands in the assembly.
Are you going to moderate the questions, or did you want?
Yeah, I'm going to. Can you give a response to that?
Oh,
or
yeah.
do you have something to? Because you mentioned the oncomosis, you have a few super interesting controversies and case studies that made me think of this, increasing optimization of some of our biological artifacts.
Well, in some ways, you're talking about how even patenting is kind of naturalized, right? So that patents are seen as natural to the process of living in a modern world. That's sort of the implicit, right? That with mechanization, right, technology is how we see ourselves, and with technology, technologies are really socio-technical systems, right? They come with them particular kinds of policies, particular kinds of laws, particular kinds of assumptions, and that includes an acceptance of a particular kind of patent system, right? So in fact, it gets naturalized, perhaps, and less a space that might, for contestation, potentially.
They contribute to the mechanization in a way, but they also, disappear as a tool for protestation or for democratic debate.
Yeah, potentially. So yeah, I guess we'll have to see. I think that's a question 100 years from now, right? Is sort of over time, and the way to maybe think about it now is, are there areas that were sites of contestation that we now don't, we now see as average parts of life that we don't challenge anymore.
If you look at the convergence of biology with more, artificial intelligence or autonomous systems, or that frontier between what's biology and what's automation, I wonder how would that change using patent as a socioeconomic protestation? Do we have question in the, yeah?
I'm J.D. Hansen from the International Center for Technology Assessment. One of my former colleagues, Tanya Simoncelli, left us and went to ACLU, so but we're happy to claim her anyway. She's now with the Broad Institute, so she's almost come full circle. That's not my question, though. One of the things European patent law has had for some time is an ability to challenge patents. And most of those challenges are business challenging business. A small percentage, I think it's about 8%, are nonprofit groups challenging the patents. In the America Patent Act, there is now a way to more easily challenge patents in the U.S. Our organization has challenged some patents, a beagle patent and a rabbit patent and a broccoli patent, but they were a big pain to go through those challenges. The first challenge is actually in the area of biotech. It's the American Simmental breeders challenged some other Simmental breeders who wanted to claim the. Anyway, I'll stop there. You don't need a lecture in cattle breeding, but.
You can help name my pet cow on my book. Good name for her yet.
Does your book look at these different ways of challenging?
Yeah.
And could you say a little more about what the differences are?
Sure.
Now that the U.S. has a little better law.
Sure. Yeah. So that's actually a central part of the book. So. Written into the European Patent Convention is this opposition mechanism, which allows any third party to challenge a patent within 9 months of its issue on any grounds or the grounds of its issue. What's interesting to me from the research that I've done is that, as you say, traditionally this is a way for companies to fight each other, just like as we were saying, that's the vast majority of challenges around intellectual property anywhere are of that kind. But the first challenges, civil society challenges, were around biotech, and pretty consistently so. What's interesting is, and they were seen as a space to have these conversations about the implications of technology. But one of the things I say in the book is that, the Patent Office had to see it as a potential place to have these conversations. And one of the first, I think the first challenges were around genetically modified plants. First civil society oppositions were around genetically modified plants, and then but they were relatively small scale. And then there was one focused on genetically modified on the oncomouse, on a genetically modified animal. And what's particularly interesting about that case is that from the EPO officials that I spoke to, that was seen as a watershed moment, because all of these, they had to change the rearrangement of the seating in the room, first of all. So they had to have overflow seating. So they were sort of confronted with all of these people that they hadn't really seen before and didn't know what to do with. But more interesting to me, anyway, still, and I talk about this in the book. The way that the opposition hearings work traditionally is that you have this board of examiners, expert examiners, and then you have the inventors, and then you have the opponents. It's on a U-shaped table usually, at least the ones that I've seen, and usually it's some kind of negotiation. They would never call it that, but it's sort of the examiners say this is appropriate. The inventor will make a recommendation. Can we change it this way? And then so it's sort of a negotiated discussion. And as this negotiated discussion was happening in the oncomouse case, this audience, right, these newcomers to the system, were grumbling, and sort of shocked, because to them, this was a way to ensure that the OncoMouse was patented, right? Just a way of narrowing the patent and negotiating. So to them, this was a demonstration that the patent office was working on behalf of the inventors and not on behalf of the public, right? So they saw those as things as, that was the moment that EPO officials said to me that crystallized for a number of them, oh, these are two different things. We have to think differently about these, right? But that plus the fact that they had to decide whether or not they were going to let these people in the room, whether or not they were going to accept the oppositions as being relevant. Do they count within the letter of the law? All of those, I would argue, are shaped by the political culture that allowed them in. So, I mean, there are now NGOs that are based in Munich, which is where the European Patent Office is, that essentially are nodes for organizations around the world that want to file oppositions at the European Patent Office. In the US case, as you suggested, right, and in fact I talk about the beagle and rabbit reexaminations in the book, as well as a few others, and ICTA, in fact, you know, the reexamination mechanism in the US, which has always been seen as the analog, was much more narrowly drawn. So initially, a third party could initiate the reexamination, but then you couldn't do anything. And then you could, in fact, interact, sort of respond. But it was only on the grounds of the patent's issue. So it narrowed it to the technical discussion, which means that, for example, in the cases that you mentioned, while ICTA tried to talk about, you know, the moral dimensions of, I think the rabbit had corneal damage, right? I forgot. Oh, the beagle had lung. Right, was engineered to have lung problems, if I recall. Those were concerns that the patent office wouldn't contend with, right? It kept saying, no, that's not relevant, we can't, right? So, but they were able to sort of, it's a combination of the political culture, but also being able to leverage the legal environment. So now, post-2011, the America Invents Act, there now is a post-grant opposition process, but the political culture is the same. Right? And there's no ordre public clause that creates a little window that can be interpreted in a particular way. So my sad conclusion would be it's still going to be very, very difficult to raise these kinds of questions, even within that newer opposition structure. But what the ACLU Myriad case tells us is that there's room for creativity, right? So you can figure it out. It just takes enormous work to figure out what those paths are because they're not as well worn and they're not as obvious, and the political culture is more hostile in the U.S. context.
So do you think approaching this through the patent window is better than sort of just taking your case to the USDA and animal welfare people and saying, hey, this is, maybe you can patent or maybe you can't, maybe that's not the point. The question is this animal cruelty and does this violate other statutes, laws, or whatever? So
if it's a question is an animal cruelty question, the USDA might be at least as relevant as a space. I think there are at least, I would say, and if you go back to the sort of questions that I was asking at the outset, there are certain kinds of questions that I think you have to think about in the context of the patent system. One is questions about the rightful inventor and sort of how does one assign reward in the context of the patent system. The second is about enclosure of the public domain, and related to that, questions around commodification that I think have a specific meaning in this context. And the third is around access and availability, open innovation, and those kinds. So those I think. So I would say for sure, what's interesting to me about this is that there are questions, some subset of these questions, and even if you look at the history, and Dan alluded to this, you know, these are debates that, you know, are certainly around genetically modified plants, right? Like, so I talk about the genetically modified plant and the history of the controversy around that. But at the same time, there are debates about genetically modified plants happening in both the US and Europe in all kinds of other spaces, right? So those debates are happening elsewhere, and the patent system just happens to be one of those spaces.
Shobita, I have a proposal for you. We have a reception with, drinks and everything, where everybody could also ask questions and get a drink. Do we want to go there, or because we're almost? I think the home has to be closed in a few minutes, right?
Yeah, the room will be open in about 15 minutes, so it'd be a good break for everyone to go to the restroom, stretch your legs for a few minutes.
And maybe buy a book.
So I don't know if there is no burning question. We might all get a drink. Do you have one there? No, we get your question then, but you have to know there is a reception where we can all get drinks and you can keep asking questions. Maybe it's a.
Well, why don't you ask your question and then we can break and.
Thank you. It's really interesting. Congratulations on your book. I bought a book. I'm really excited to read it. You talk about enclosing the public space. What about out-competing the public space? And it occurs to me that, and is this valid to think this way? That one of the unintended consequences, perhaps, of patenting is this. It seems like we're patenting more things, we're creating more things, kind of just to identify them, to name them, to change them, whether or not they're needed, whether or not they're beneficial, just to sort of, okay, we've got that thing, we've got that thing, we've got, kind of the creation of so many things, so much complexity, which makes it harder to govern. And some of these, if they can reproduce, put the public, sphere, what's naturally reproducing, at risk, potentially, of being outcompeted. Is that a domain of concern? And could you speak to that?
Yeah, that's, I think, potentially, sorry.
And how do we identify which office to go to speak to about that? And how do we get into a design orientation with regard to having an office like that? Harder question.
Well, I think some of these issues are certainly coming up in the domain of synthetic biology, right? So, what parts of that are patentable? And then if you're creating an organization or organism that's potentially self-replicating, how does ownership figure in those contexts? We've already dealt with it legally in the context of exhaustion. So there are these court cases around when does a patent get exhausted, and the answer, at least in the biotech arena, certainly is it doesn't. So if someone discards a patented seed, for example, and you pick it up and you plant it again, you're still liable to the patent holder for that. So that suggests, those kinds of decisions suggest that ownership extends across generations, which raises, I think, important ethical questions. The other thing I would also add that I often think about too, when I see these these graphs that demonstrate sort of increases in patents that are often demonstrated as or often shown as demonstrations of a country's vitality, economic vitality, is not just that more things are being patented, but you might have patented this before, but now you're patenting the top and the middle and the bottom. So there's sort of a lot of effort to kind of split up ownership and in order to extend the life of your patent. You might get the patent on this first and then this a couple of years later, so that and these two things work together. So there are those kinds of things. And in terms of where do you go to have conversations like this, I mean, I think one of the things that in part inspired my interest in the book, and is certainly I continue to think about and struggle with, is that we tend to think about questions like the one that you're asking, or some of the ones that arise in the context of the patent system, as ungovernable, right? In the context of ethical questions, certainly in the U.S. context, we tend to think about, okay, well, that's the decision of the individual consumer. If you buy it, then you're into it, or otherwise not. So we we tend to think about those kinds of concerns, those ethical concerns in particular, as being, oh, well, we have all these competing ideas of morality, and so therefore we can't create governance structures to address them. But one of the things that interested me about this this comparison in the European context was that they, and you see this in other areas of science and technology more in the European context than you do in the U.S., which is that there are attempts to, that's not the default assumption. The default assumption is this is potentially governable. Now we have to muck around and figure that out. And it might be messy, but we have to figure out how to develop a governance structure. And so that's the interesting question for me, is how do we think about governance in a systematic way of things that might not be easily quantifiable, and may not be easy, in the ways that risk seems to be the way that we can easily govern. But there are, in fact, emerging technologies raise all of these kinds of questions, and those are the things that I think we haven't yet grappled with in terms of governance well enough yet. But there are lots of people talking about them in this town and as well as in universities. So.
So I think we can come to an end. Thank you so much for your amazing presentation, Shobita. It was really in-depth, and it kept us, on a Friday so long here. So we will all, go to our weekend with maybe new ideas to fight against commodification and an interesting read in perspective. So there is a reception on the 6th floor in the dining room with food and drinks, and we can all keep discussing and maybe getting more questions to you. So thank you so much to Shobita, our panelist, and my colleague Liz, who disappeared but who helped tremendously to organize
absolutely.
this. So thank you so much.
Thank you so much.